Good day! Welcome to Lawyer Up by NDV Law. This is Atty. Nikki de Vega, Managing Partner of Nicolas and de Vega Law Offices. In today's video, I will talk about cartel criminalization and leniency policies in the Philippines. Hardcore cartels are classified as the most egregious violations of competition law, and that the they injure consumers in many countries by raising prices and restricting supply, thus making goods and services completely unavailable to some purchasers and unnecessarily expensive for others. Many jurisdictions, such as the US and Australia, provide for criminal sanctions against cartelists. The US Antitrust Division has long emphasized that the most effective way to deter and punish cartel activity is to hold culpable individuals accountable by seeking jail sentences. Among OECD members, there is a trend towards accepting that sanctions against individuals can contribute to more effective anti-cartel enforcement. In the Philippines, cartel conduct, such as agreements among competitors regarding restricting competition as to price and other terms of trade, also bid rigging, controlling production, market allocation, are considered as criminal offenses. In addition to administrative fines, cartel conduct is punished with imprisonment ranging from 2 years to 7 years, and a fine not less than a whopping 50 million pesos, but not more than 250 million pesos for each and every violation. The significance of cartel criminalization in the effectiveness of law enforcement is supplemented by efficient leniency policies. In order to be effective, there must be existing laws with severe sanctions for cartel conduct, such that a cartelist would prefer to avail of the leniency program than face the threat of sanction. Leniency policies can also augment detection and enforcement tools of competition officials. Since cartel activities are usually clandestine or done in secret, these activities can be detected if an insider comes forward and supplies the information. Such information, coupled with documentary and testimonial evidence, may provide sufficient basis to convict individuals. Otherwise, it is quite difficult to meet the quantum of proof required of criminal prosecution, namely, that is, proof beyond reasonable doubt. The Philippine Competition Commission, or in shortcut PCC, is tasked to develop a leniency program for cartels. Immunity will be granted to the participants of the covered acts if they voluntarily disclose information before a fact-finding or a preliminary inquiry has begun, provided that the following conditions are met. Number 1, at the time the entity comes forward, the Commission has not yet received any information about the activity from any other source. Number 2, upon the entity's discovery of illegal activity, it took prompt and effective action to terminate its participation therein. Number 3, the entity reports the wrongdoing with candor and completeness and provides full, continuing, and complete cooperation throughout the investigation. And 4, the entity did not coerce another party to participate in the activity and clearly was not the leader in or the originator of the activity. Nevertheless, even after the PCC has received information about the illegal activity after a fact-finding or preliminary inquiry has commenced, the participant will still be granted leniency provided that the second and third conditions that I previously mentioned are present, coupled with the following additional requirements. Number one, the entity is the first to come forward and qualify for leniency. Number two, at the time the entity comes forward, the PCC or the commission does not have evidence against the entity that is likely to result in a sustainable conviction. And number three, the PCC or the commission determines that granting leniency would not be unfair to the others. The effect of the grant of leniency to the disclosing entity will either be immunity from suit or reduction of the fines. An entity cooperating or furnishing information, document, or data to the PCC in connection to an investigation being conducted shall not be subjected to any form of reprisal or discrimination. In addition to the leniency program, an entity charged in a criminal proceeding involving cartel conduct may enter a plea of nolo contendere. This means that the accused will neither accept nor deny responsibility for the charges, but nevertheless agrees to accept punishment as if he had pleaded guilty. The plea cannot be used against the defendant entity to prove liability in a civil suit arising from the criminal action, nor in another cause of action, provided that a plea of nolo contendere may be entered only up to arraignment and subsequently only with the permission of the court, which shall accept it only after weighing its effect on the parties, the public, and the administration of justice. So that, folks, is the status of cartel criminalization and leniency policies in the Philippines. Well, if this video has been helpful, kindly subscribe to our YouTube channel by clicking on the subscribe button. Again, this is Atty. Nikki de Vega, Managing Partner of Nicolas and de Vega Law Offices. And thank you very much for watching Lawyer Up by NDV Law.